Head down and thumb up. No. His partner though, 2 years older than him, so I think it would shortly.
Silence or stand. The Coroner's Court of the Northern Territory is now in question. Be seated.
Thank you. Yes, I'm told that the live stream is now working again. So I come to the findings that your counsel assisting team urge on, Your Honour, in relation to the 9th of November 2019. It's respectfully submitted, Your Honour, that Constable Rolfe and Kumanjayi Walker should never have been in the room together on that evening in those circumstances. They likely would not have been if Mr Rolfe had been disciplined and investigated properly and in a timely manner. They likely would not have been, in terms of Mr Rolfe, would not have been eligible for deployment if he had been investigated and disciplined in a timely manner. Similarly, he shouldn't have been eligible for deployment if Mr Rolfe or CV had shared concerns in relation to Mr Rolfe's mental health decline, which were evident from the text messages close to the events of the 9th of November. They should never have been in the room together that night in those circumstances, even if he was deployed, if Mr Rolfe and Constable Kirstenfeld had not disregarded the arrest plan that had been formulated by much more senior and experienced officers. In effect, what we have submitted in our written submissions, and which I will take Your Honour through briefly now, is that Mr Rolfe took over as effective de facto leader on the 9th of November and bears ultimate responsibility for what went wrong with Kumanjayi Walker. It was a failed operation in which he put himself, Officer Ebel and Kumanjayi at risk, or increased the risk of what happened occurring. Your Honour has heard much throughout the inquest in relation to the arrest plan, and just to remind the court briefly of some of the salient points of it, the arrest plan was set out to involve the IRT members, Ebel, Hawkins, Rolfe and Kirstenfeld, the dog squad operator Donaldson, and local members Felix Alafeo and Sergeant Julie Frost. It mentioned only that member Hand was to remain separate to the operation due to the conflict of interest. It clearly set out a plan for Saturday, 11 p.m, IRT commence duty and conduct high visibility patrols and respond to call-outs. On a Sunday morning, the 10th of November 2019, the arrest of Kumanjayi was to commence. 5 a.m, Donaldson and Yundamu Alafeo commenced duty along with IRT members to effect the arrest of Kumanjayi. It referred to the earlier acts incident on the 6th of November to put police on alert in relation to that. It stated that of note the funeral was taking place in the community this weekend, and it provided a local presence. It stated that there was to be a local presence of armed police to uphold law and order in the community and provide support to local members. Specifically, of course, as I've already pointed out, it provided that a local member, Constable Alafeo, would assist, and there was a significant benefit in that. It may be that after the event, the court might consider that the 5 a.m. arrest plan might not have been foolproof, but it had very clear advantages over the haphazard and risky alternative that was ultimately determined by Constable Rolfe. Most significantly, it would occur in the early hours of the morning when Kumanjayi Walker was likely asleep. It would not have occurred immediately after Kumanjayi Walker had just been at sorry business and funeral process. And most importantly, there was a local member who would recognise who Kumanjayi Walker was, so that there would be no need for the very risky situation that Mr. Rolfe put himself in and put Constable Ebel in, of going right up to Kumanjayi in very close quarters and holding his phone close to his face, increasing the risk of exactly what occurred happening in circumstances where he knew there had been an aggressive confrontation on the 6th of November. The findings that we submit with respect, Your Honour, should make in relation to this are carefully set out in written submissions. Your Honour would find, with respect, that Officer Donaldson clearly knew of the 5 a.m. arrest plan, and that's consistent with his evidence. This is set out from paragraph 546. At approximately 5:49 p.m, Sergeant Frost and Constable Donaldson enter the muster room at Yuendamu, and there's a briefing. They remain there for 30 minutes, during which time Constable Donaldson was briefed on recent events and was briefed on the arrest plan. He was provided with a copy of that operations order. Constable Donaldson read the ops order then and there, according to his evidence. He knew Sergeant Frost was his senior officer, and that having been handed with that document, it was his duty to read the document carefully. He was told and well understood from the ops order that the plan was that the IRT would be there assisting with the unlawful entries of nurses' quarters to start with, and that the attempted arrest of Kumanjayi was planned for the following day. He understood that this plan had been designed in tandem with Sergeant Frost and Superintendent Nobbs, and that the ultimate approval had come from Superintendent Nobbs. He can be seen to leave Yuendamu Police Station at 6:18. At approximately 6:33 p.m, Constable Kirstenfeld and Mr. Rolfe can be seen entering Yuendamu Police Station, crossing a corridor and entering the muster room. They spoke with Sergeant Frost in what Your Honour would find was a very challenging conversation for her. Your Honour would find that the evidence is compelling, that those officers, and in particular Constable Kirstenfeld, were clearly uninterested in what Sergeant Frost had to say. Constable Kirstenfeld in particular wasn't really prepared to listen to what Sergeant Frost was saying, and gave the impression that he was, quote, totally trying to take over the station at that point in time. It's nevertheless clear in our respectful submission that Sergeant Frost did inform Mr. Rolfe and Constable Kirstenfeld of the existence of the 5 a.m. arrest plan. Your Honour would find that there is essentially consistency between the accounts of Sergeant Frost, Constable Alafeo and Mr. Rolfe on this issue, that is, that they were told about the 5 a.m. arrest plan. And this is set out in detail and a number of points are made, but I just note this. Mr. Rolfe's evidence, even at trial and inquest, assumed his knowledge of that plan. He gave evidence that it was he who raised with Sergeant Frost his concern that the 5 a.m. arrest plan required more intelligence, and hence he suggested that the IRT would, consistent with their approach, and I quote, introduce ourselves to the community while attempting to gather intelligence about a person that we are generally trying to locate, and at the same time trying to gain community assistance for our task. But at no stage did Sergeant Frost advise him that the 5 a.m. arrest plan had changed. For the reasons set out in our written submissions, Your Honour would find that Senior Constable Hawkins and Constable Ebel, regrettably, were not adequately briefed and were not briefed on the 5 a.m. arrest plan. Upon his return at approximately 7 p.m, Constable Donaldson found each of the 4 members of the IRT in the muster room gathered around a desk, and his evidence is clear that Zach Rolfe was giving a brief on where we were going to. Mr. Rolfe was taking charge in terms of directing Constable Ebel and the other officers from the IRT about what would happen next. That is the evidence of Constable Donaldson and Constable Ebel. As to the context of that briefing or discussion, Your Honour would find that in substance Mr. Rolfe was briefing the members on the immediate attempt to arrest Kumanjayi Walker by attending, entering and searching houses 577 and 511. That is, he was acting in disregard of the arrest plan and he was briefing them on something different, an immediate arrest. That's consistent with Mr. Rolfe's status as de facto team leader, self-appointed, and the interest that he had shown during the preceding 3 days in securing Kumanjayi's arrest. Constable Hawkins, who Your Honour would accept along with Officer Ebel as a credible witness, told investigators just 4 days after the shooting that the tenor of Mr. Rolfe's briefing was, and I quote, "Let's get in there and let's pretty much get out there and locate him." The briefing conveyed that the idea was to go back to the station, hopefully identify him, locate him quickly, and then return back to the station and come back to Alice Springs. The substance of the briefing given by Mr. Rolfe was that the best intel was that Kumanjayi was at house 577 or house 511, and the IRT would go to those locations where Mr. Rolfe and Constable Kirstenfeld would effect a standard entry to the address, with Senior Constable Hawkins and Ebel taking the back in the event that he runs. Officer Hawkins said, in response to questions asked by Mr. Edwardson, put simply, the plan was to locate Kumanjayi Walker, who would be immediately arrested. Constable Ebel gave, in effect, the same account. When asked whether he left the Yuendamu police station at 7:06 p.m. with a plan to arrest Kumanjayi, he answered definitely, yep. Similarly, Constable Donaldson understood the plan as outlined by Mr. Rolfe to be inconsistent with the plan that he had been briefed on earlier that day by Sergeant Frost. So different was this briefing to the plan outlined by Sergeant Frost that Constable Donaldson assumed that there must have been a conversation between Sergeant Frost and the IRT that he hadn't been privy to, during which the plan had changed. But Constable Hawkins' evidence is consistent with Sergeant Frost that she wasn't part of the subsequent briefing. There is a very unfortunate miscommunication between some members of the IRT and Sergeant Frost. But in our respectful submission, there was a deliberate failure to follow the arrest plan by Officer Rolfe. And he led, that is he and Constable Kirstenfeld, led the officers astray, but Mr. Rolfe in particular assumes responsibility when he appoints himself as de facto leader. It's submitted on behalf of Mr. Rolfe that Constable Alafeo was told to stay behind. That's at paragraph 139 of their submissions. That misstates the evidence, including the evidence of Constable Alafeo, who explained to the court that he understood that he was required to meet them at the station at 5:30 to assist with the arrest. It's put on behalf of Mr. Rolfe at paragraph 156 of the submissions. In any event, that is, as if putting aside the arrest plan, that's not what any respectable police officer would do if told the arrest plan was for 5 a.m. I've already put to Your Honour what the advantages of the 5 a.m. arrest plan were over this haphazard plan that Mr. Rolfe appears to have devised. And it came from senior experienced officers who should not have been disregarded. What happened next was not intelligence gathering, as suggested by Mr. Rolfe. Your Honour is urged by those who appear for him to put aside the semantics of what amounts to intelligence gathering. Mr. Rolfe says in paragraph 153, page 39, digressing to semantics on the true scope and definition of what intelligence gathering is a futile exercise. This is not semantics, Your Honour. What happened after Mr. Rolfe and the IRT members left Yuendamu Police Station after 7 o'clock is fundamentally different to what was intended. As Superintendent Nodds explained in a compelling way, there was no point intel gathering at 7 p.m. about where Mr. Rolfe might be likely to be at 5 a.m. by going to the place that he usually slept. Your Honour, it's suggested by those who appear for Mr Rolfe that the coroner can't rely on the evidence of Officer Meacham King that this was not intel gathering. There's a complaint in their submissions on behalf of Mr Rolfe that Your Honour refused to allow the recalling of Officer King after the racist certificates, so-called certificates, Christmas certificates, appeared. Firstly, Your Honour, the request for Officer King to be recalled would have added further time and resources to an inquest which has already run over time, another complaint made on behalf of Mr Rolfe. It was entirely reasonable to deal with any issue in relation to Meacham King by written submissions and oral submissions. And further, the evidence about racist certificates is unrelated to intelligence gathering. But if Your Honour does not wish to rely on the evidence of Meacham King that this was not intelligence gathering, Your Honour need not do so. The evidence that this was not intel gathering comes from other highly credible sources. And I note in particular the evidence of Superintendent Nobbs, transcript page 1116, the evidence of former Commander Proctor in the brief, document 1-1 at page 69, and the evidence of former Superintendent Pollock 1-2 at page 19. Superintendent Nobbs said in his evidence this: "I spent probably 6 months not sleeping, going, how can something so simple in my mind have become what it ultimately became?" It's an example of how reflective he was, and no doubt many other officers who had had some involvement in the development of this plan or the events of 9th of November, and the angst that it has caused the Northern Territory Police Force when this went so terribly wrong. But the answer to the question of how something so simple in my mind could have gone so wrong is because, and the arrest plan that had been agreed to and formulated by Sergeant Frost was not followed, and Superintendent Nobbs was not consulted about the change in that plan. I have made the point already that ego had a lot to do with the tragic end result. Mr Rolfe and Mr Kirstenfeld, when they were at the station, thought they were better than the plan that had been devised by the community police officer. Mr Rolfe in particular demonstrated contempt when he then became a team leader effectively and disregarded the arrest plan and conducted his own briefing on something different. Mr Rolfe and Constable Kirstenfeld claimed that they did not read the arrest plan for the reasons set out carefully in our written submissions. Your Honour would reject the suggestion that the arrest plan was not provided to those officers. Your Honour would find, as set out at paragraph 557, they were briefed orally on the 5 a.m. arrest plan. It's most likely that briefing occurred between 6:33 and 6:56 p.m. That is prior to the arrival of Senior Constable Hawkins and Constable Eberl. Mr Rolfe and Constable Kirstenfeld well understood that Sergeant Frost's expectation was that they provide high visibility policing in 2 shifts before reconvening at Yuendamu Police Station at 5 a.m. for the planned arrest. They well understood that Constable Alafeo was to meet them at that time and at that location for that purpose. That finding is compelled by the evidence of Sergeant Frost, the evidence of Constable Alafeo, who heard Sergeant Frost brief the members on the 5 a.m. arrest plan, and Mr Rolfe's own evidence at trial and inquest, which tacitly accept that he was aware of the 5 a.m. arrest plan. Your Honour would find that Mr Rolfe, at least, if not Mr Kirstenfeld, Mr Rolfe was provided with a copy of the written ops order which outlined the plan and that he knew of its contents. That finding is compelled by the evidence of Sergeant Frost, the fact that Mr Rolfe took photographs of the ops order and therefore must have been aware of it, and the improbability that Mr Rolfe, who was otherwise focused on gathering intel, would have overlooked the very page he was photographing in terms of the fact that he'd outlined the more detailed plan for Kumanjayi's arrest. It follows then, Your Honour, that Mr Rolfe lied at trial in the inquest when he gave evidence that he was not aware of the fact or content of the ops order. And he told that lie because he knew that the truth, which was that he had received the document, tended to prove that he was aware of the 5:30 a.m. arrest plan. And he actively knew he had deviated from that plan when he sought to arrest Kumanjayi Walker shortly after 7 p.m. on the 9th of November 2019. We have made the point in written submissions that Officers Eberl and Hawkins were most likely not briefed on that plan. They were following Officer Rolfe's lead and they acted in good faith in doing so. In my respectful submission, Constable Eberl and Hawkins would have impressed, Your Honour, as good officers who genuinely thought they were following the approved instructions, and they were led astray by Officers Rolfe and Kirstenfeld. Eberl in particular was put at risk because of the arrest plan. We deal in some detail with whether there was permission to enter the house. That is a complicated and somewhat technical area of law dealt with fully in written submissions. I propose to deal briefly then with what happened inside the house. Your Honour should make, with respect, the following findings regarding Mr Rolfe's conduct once inside House 511. This is set out at paragraph 562. In keeping with his tendency to rush into situations without regard for his or others' safety and his tendency to want to get his man at all costs, Mr Rolfe immediately closed the gap between him and Kumanjayi Walker, created a situation in which the very risks that had arisen during the 6th of November 2019 attempted arrest were repeated. Second, Mr Rolfe's account of Kumanjayi Walker reaching for his gun was an invention. It was added to his account for the first time when giving evidence at trial 2.5 years after the events. That's a significant finding, Your Honour, and I make it carefully and after careful consideration, and we have set out the evidence in full. Your Honour would find the following. If that were true, that Kumanjayi had in fact attempted to obtain Mr Rolfe's firearm, that would have been understood by Mr Rolfe to be one of the most significant pieces of evidence in respect to his claim of self-defence. He conceded at this inquest that the significance of Kumanjayi putting his hand on his Glock is that he could have then withdrawn the weapon potentially and shot him. And to lose control of his service weapon was one of the most serious things that could happen to a police officer. And yet, Mr Rolfe did not tell Brianna Boney of it, a fellow officer, when describing the incident to her in the morning after the shooting between 2 a.m. and 3 a.m. on the 10th of November. He didn't write the detail down in his otherwise detailed police notebook entry describing the shooting. He gave lengthy and detailed interviews on the 5th of December 2019 to Kirsten Shorten of The Australian, who Mr Rolfe knew was sympathetic to him, in part because she had informed him that she was happy to, quote, write an article in his defence. During the interview, Mr Rolfe described the shooting of Mr Walker in great detail. Indeed, he did so on camera in more than one take. And in not one of those takes did Mr Rolfe mention that Kumanjayi Walker had put his hand on his Glock. In not one of those takes. On the 5th of December 2019, less than a month after Kumanjayi's death. As a result of this lie, the lies Mr Rolfe told regarding the broader events of the 9th of November 2019 and the significant issues with respect to his credibility as a historian of his own use of force mean that Your Honour couldn't accept, even on balance, that Mr Rolfe's evidence that he feared for his or Constable Eberl's life when he fatally shot Kumanjayi Walker can be accepted. There is evidence that supports Mr Rolfe's claim that he genuinely feared for Constable Eberl's life, but there is, however, also a substantial body of evidence that supports a more sinister hypothesis, namely that as a result of his fascination with violence, the extent to which he had dehumanised Aboriginal people and his desire to, I quote, shoot someone to go on a paid holiday, as he said to Ms Campagnaro, means that he set out to create a situation in which he could justify using lethal force against Kumanjayi, or at least when presented with the opportunity, that is what he chose to do, consistent with what were his values. The text messages exchanged by Mr Rolfe in the days immediately followed Kumanjayi's death demonstrated that he believed he would be lionised as a result of this death. He was shocked when his conduct was subject to criticism and ultimately the subject of a criminal charge. It's a matter for Your Honour whether you accept those submissions of counsel assisting, of course, carefully listening to the evidence of all of those who have appeared with an interest in this inquest. But those submissions are not resolved from. I note the submissions of the Paramparoo Committee at paragraph 60 to 69 that it is extraordinary that the evidence in relation to Kumanjayi Walker allegedly going for Mr Rolfe's Glock were not put to Sergeant Barham at trial. They were not put to the witnesses at trial at any time prior to or at committal. And that story emerged for the first time when former Constable Rolfe was giving evidence at trial. Your Honour would find that inside the Red House, what happened was a classic example of officer-induced jeopardy, and that is clear from the evidence of former Superintendents Proctor and Pollock, Sergeant Barham and Mr Alpert. On behalf of Mr Rolfe, his legal team complains at paragraph 11 of their submissions, and I quote, that not a single party in the near 100 pages of submissions has analysed the evidence of the only credible use of force expert in this case, former Federal Police Commissioner Benjamin McDevitt, the architect of the use of force policy and principles that underpin the Northern Territory Police Force training, which applied to Rolfe on the 9th of November. I reject the suggestion that he was the only credible use of force expert in this case, but Your Honour will no doubt take careful note of the evidence that he gave. In relation to the concept of officer-induced jeopardy or similar concepts, he considered that while he said that Mr Rolfe had acted in accordance with his training once inside House 511, he also considered it was necessary to take a broader view and not just focus on the events that occurred inside House 511, and that's transcript page 4569. He was critical of the officers inside House 511 closing the gap between themselves and Kumanjayi too quickly. He said, and I quote, "I think the problem for them, and I've seen it on multiple occasions, that they seem to have put the priority of identification of who it was that they were talking to up front, and that led them, I think, to close the gap with Mr Walker, which, I think they shouldn't have done. They could have established his identity from a safer distance, if you like." And I pause to note, of course, that they wouldn't have had to do that if Constable Alafeo had been with them in accordance with the 5 a.m. arrest plan formulated. It's then put to him by Mr Coleridge, and indeed I think that's exactly what you said at trial, page 1262, that this singular focus on getting in there and establishing identity and closing the gap meant, in your opinion, that there wasn't enough focus on their own safety, for example, and he said, yes, that's correct. There are more general points from Mr McDevitt. I understand, Your Honour, will have read his evidence carefully and also the submissions made on behalf of Mr Rolfe in respect to his evidence. Mr McDevitt commenced his oral evidence at inquest by saying, "Obviously I am Cardia, not Yappa, and I do not have any in-depth knowledge or understanding of Warlpiri history, language or customs. I think that like many Australians, many Cardia, I am poorer for not having this knowledge or understanding." He stressed the importance of understanding things like bias and racism when assessing use of force and training officers in the use of force. He said that when teaching officers to use force safely and when assessing their use of force in hindsight, bias and cultural awareness training was vital. He said that it was vital that police officers ask, what bias and cultural baggage are we carrying? He said that even subtle biases could still influence police decision-making about the use of force in ways that needed to be avoided or confronted. He said that a racial bias might cause the officer to assess a person of a particular race as being at greater risk to the officer, and he agreed that in large part his report recommended to ensure the use of force by an officer, racial biases need to be identified and confronted by police officers. I remind Your Honour of the evidence of psychologist Mr Van Heften in an exchange with Mr Officer, when he said that decisions officers make, as well as their training, will be influenced by their attitudes and values. What a great reminder of the importance of reinforcing good attitudes and good values in the Northern Territory. The officers who created the arrest plan have reflected on it and have given evidence carefully in this inquest. And there are detailed submissions in our written submissions in relation to the evidence of the communication about the arrest plan up the chain. All of those persons, including, of course, Superintendent Nobbs, Sergeant Frost, and the Assistant Commissioner Wurst and the other officers who were engaged in the arrest plan and communicating it, acted in good faith, and they considered that they were following the chain of command. They were running decisions up and down the line as expected. Each of them checked the arrest plan. None of them went off on a frolic of their own. That is what you would expect reasonable police to do. They did not anticipate a change in that plan. I just have, we'll deal with the remaining issues very quickly. The actions after Kumanjayi shot were very distressing and they occurred in a volatile and emotional situation. I agree with respect with the submissions made on behalf of Constable Rolfe that Your Honour should not be critical of the failure to treat Kumanjayi at the scene. Should not be critical of the failure to secure the scene as a crime scene immediately. It is an almost impossible position for us to put ourselves in what those officers were then facing in terms of the scene after Kumanjayi was shot. But having a crowd of distressed people may well have hindered the treatment in terms of the CPR that was required urgently and the management of the scene. I also agree with respect with the submissions made on behalf of Constable Rolfe that there's no basis to criticise the CPR efforts in spite of the absence of mouth-to-mouth CPR. In my respectful submission, Officers Rolfe and all the officers there did their best to administer CPR after Kumanjayi was shot in circumstances where, compounding this tragedy, the clinic was closed and made it very difficult to administer proper care. Kumanjayi passed away relatively quickly because of the injury to his major organs. In my opening submissions, I said this: Constable Rolfe and Senior Constable Kirstenfeld headed the resuscitation efforts, given their significant training in military first aid experience. I expect, Your Honour, to hear that they did everything they could to try to sustain Kumanjayi's life, including packing the wound to stop bleeding and making him as comfortable as they could. And in fact, that's the evidence that was borne out. The submissions on behalf of Mr Rolfe complained that nobody sought to play the revival efforts. There was no difficulty with anybody playing the revival efforts, but of course it wasn't necessary to play them in open court. They're distressing. Your Honour has seen those revival efforts and wouldn't be critical of them. I endorse the submission made on behalf of Mr Rolfe that there was professionalism and care shown in respect of those CPR efforts. That's understandably maybe of little comfort to the family, given the circumstances as to why Kumanjayi was there in the first place. I do note, Your Honour, the particular empathy shown by Officer Ebel to Constable Rolfe, I withdraw that. I note the particular empathetic response by Officer Ebel, which is clear from the video, and I commend to Your Honour the efforts to engage in CPR. Back at the station, there was a ruse by police for some time to suggest that Kumanjayi was still alive. That is deeply regrettable, deeply hurtful. But in the submissions of Your Honour's counsel assisting, it was a very, very difficult situation, and the ruse is not an example of racism. In my respectful submission, I appreciate Your Honour will hear submissions to the contrary by the family, Paramparoo Committee and Najar, but we do not adopt those submissions. Accept that the community as a whole were behaving in a restrained manner, but there were examples of some people who were not. We've got to be realistic about what happened and what the police were facing on that night after Kumanjayi was shot. There were rocks that were hurled onto the roof, and there was a nurse who was significantly hurt. And we can't sugarcoat that. We just need to be looked at realistically. Even a few people acting in a way that is dangerous can cause serious danger. It's fair enough that police were aware of how volatile the situation was in circumstances where they were a long way away from any backup. It's acknowledged, Your Honour, that as a result of that ruse, there is a lot of repair to be done with this community. It's acknowledged that the community have suffered in terms of a lack of trust of police after this event. And it demonstrates the need for serious reconciliation and better communication between police and community members so those fears can be alleviated. I commend to Your Honour in particular the efforts made by Sergeant Frost to try and heal some of the significant wounds after Kumanjayi's passing, but there are other officers, of course, too, senior officers and junior officers who've made significant efforts in Yuendamu, and those efforts must be doubled down on and supported. There is a significant role for elders and leaders in the community in building relationships. I acknowledge on behalf of the council assisting team the extraordinary leadership of the elders and young leaders on that night, including, of course, Eric Williams, Ned Hargraves, Samara and others. Mr Rolfe, as I've already said, expected to be lionised as a result of those tragic events, but experienced, mature, thoughtful officers like Sergeant Frost, Officer Hand, Superintendent Nobbs and beyond knew the true extent of that tragedy and the trauma to follow. In the days that followed Kumanjayi's death, the text messages exchanged between Mr Rolfe and some of his friends show an immaturity and a lack of sensitivity. "Stoked for you, bro," wrote one person. "Let's see them keep you out of the TRG now." That might just be bravado in difficult circumstances, but it certainly shows a lack of empathy for Kumanjayi's family. Compare Superintendent Nobbs, who, in a demonstration of his maturity and sensitivity, told the court he lost 6 months of sleep and beyond, trying to work out how this went so wrong. And Your Honour will reflect on the emotions exhibited by a number of officers, including Officers Hand and Smith and Sergeant Jolly and Sergeant Frost, about how devastated they were in relation to Kumanjayi's passing. We have dealt in our written submissions with the gathering that happened at Mr Rolfe's house after Kumanjayi passed, which was inappropriate and allowed for the exchange of information that would have been, or that might have been relevant in relation to building a defence for Mr Rolfe at trial. However, it's also clear that there were inappropriate supports for, or insufficient supports for some of the officers involved, and police and people will potentially make poor decisions about how to support each other when there is a vacuum of adequate supports from senior officers and institutions. There needs to be clear policies and procedures in place for police exposed to traumatic events so that they are not left alone. And I commend to Your Honour some submissions made by the Northern Territory Police Association in that regard. So the final topic, Your Honour, relates to supports to police. To avoid a further tragedy, we need to acknowledge the very difficult job that Northern Territory Police Force do, reflecting again on the levels of trauma that Your Honour has recently spoken about in other inquests and acknowledged in this inquest. Quote, Your Honour, from the Northern Territory Police Association. Give me 1 moment, sorry. The association submissions refer to the evidence of officers about the importance of community policing and engaging with the community. They also note, however, that in the lead up to Kumanjayi's passing, the officers at Yuendamu were impacted by extreme levels of fatigue, and that must be addressed if we're serious about officers being able to spend time engaging positively with the community. They quote Superintendent Nobbs discussing the work of police in relation to coordinating meetings about family violence prevention programs and others. And they note that Superintendent Nobbs stated that he encouraged officers working under his command, this is at paragraph 15 of their primary submissions, to bring the conversation to the people rather than scheduling meetings which no one attended and simply saying, well, now it's past 3, so no one's here, so let's wrap up and go home. He acknowledged the importance of community interaction and engagement and building relationships with local people, saying he would often say to his place, I don't care if you come to work tomorrow in your PT gear and you kick a footy all day, if the opportunity presents, go do it. As the NTPA says, that sentiment expressed is valid. And the NTPA say the importance of police members being engaged in the community in which they live and work cannot be understated, both for the benefit of the community and the welfare of the members. It's so important, Your Honour, that officers have the opportunity for all the positive cultural engagement that community living can offer and positive cultural engagement that living in the Northern Territory can offer. The NTPA go on to point out that the reality of policing in Yuendamu, up to and including 2019, was that the station was at times under-resourced, gazetted and relief members were working excessive overtime hours, they were offered little respite, and even on designated days, they were to be reasonably available to be called back to duty. So the welfare of police does need to be prioritised in order that they can engage in positive community activity and to engage in all the training in relation to use of force and combating racism that is required. In relation to the issue of racism more broadly, we have set out some of the concerns in our written submissions. One suggested recommendation is that the Northern Territory Police Force should set up a working group with representatives from the main agencies affected, Police, NAJAR, NT Legal Aid and the Ombudsman, to discuss good communication and procedures for addressing complaints made by Aboriginal people about police use of force and allegations of racism. I understand that that is a recommendation that may be supported by Northern Territory Police. I acknowledge that there are some encouraging signs that Northern Territory Police have taken these issues seriously. Mr Murphy acknowledged that they do have an issue in relation to combating racism in the Northern Territory Police Force. I acknowledge the appointment of Leanne Little to the executive. Her title is Executive Director of Community Resilience and Engagement Command. I anticipate Your Honour will hear about some significant reforms already introduced. I acknowledge the other encouraging signs, including an apology from Commissioner Murphy earlier this year for the racism that was acknowledged to have been revealed as a result of this inquest. The NTPA refer to a welfare strategy, various supports and a fatigue management policy, and I commend those submissions. Your Honour, again, I propose to put out draft recommendations that adapt and adopt some of those. Commend to Your Honour the suggestions that there must be leadership from the top of the Northern Territory Police and there must be leadership from Northern Territory Aboriginal communities which is properly engaged in. That might include, for example, boosting night patrols and considering further ways to work with community. Those are my submissions for the moment. Your Honour, I propose just to use the remaining 15 minutes at the end of proceedings.
Thank you, Dr Dwyer. Yes, Mr Mullins.
Your Honour, on 5 September 2022, the first day of this hearing in Alice Springs, there were several tents erected on the court lawns across the road from this courthouse. In front of those tents and directly opposite the entrance to the courthouse, there was a sign, and the sign included 3 words, "Tell the truth." The Brown family, other members of the Yuendamu community and their supporters have been present on the court lawns each day that evidence has been given before Your Honour. And the message to tell the truth has never changed. From the Brown family's perspective, the court lawns have been an important component of this inquest. The lawns have provided an opportunity for family members and supporters of the family to connect in their own space. They allow people to express solidarity in a place that is different from the courthouse, but close enough to be connected. It allows family and supporters to meet and share, for open discussion, for questions to be asked and answered, for each voice to be heard, and for opinions to be expressed. It offers the opportunity for elders to give guidance and for young people to speak their mind. The court lawns have and will continue to provide a waiting place where many Aboriginal people will gather. The message to tell the truth that was being delivered to the lawyers, witnesses, media and other participants who attended the inquest had been sent long before the inquest commenced. The Brown family called for the truth to be told in the days immediately following the shooting. At the time of the committal proceedings, Brown family members in the community gathered on the court lawns to show support for each other and to call for the truth. They again gathered on the court lawns during the course of the criminal trial in Darwin to support their family who had travelled to Darwin to be present for the trial. Your Honour has heard extensive and uncontested evidence about the devastation of the Warlpiri people over the last century. As Dr. Hinkson observes, prior to the establishment of Yuendamu as a ration depot in 1946, the Warlpiri lived as hunter-gatherers, harvesting food across their lands and living through customary law. Pastoralists moved onto their land and suffocated their traditional hunting and food sources. They were shattered by the Coniston massacre in 1928, and the memory and legacy of that time remains with them today. They witnessed a flawed and prejudiced federal government investigation into those crimes. They suffered the devastation of the 1940s and 1950s, becoming subjected to the protection and preservation era policies. They became wards of the state, unable to vote, restricted in their movements, and in the use of Warlpiri custom and language. Many of their children were stolen from their families in the 1960s and thereafter. It is impossible for outsiders to truly comprehend the theft of a child from her parents and the grief both the child and the parent would feel on that separation. But this policy was forced upon them and they have lived with it for decades. They continue to live every day with the consequences of that policy. In the early 1970s until the mid-1990s, a policy of self-determination and self-management inspired community activity and development. By the 1990s, Dr. Hinkson herself observed in Yuendamu an imperfect but vibrant scene of intercultural activity. There were many community-controlled incorporated organisations and councils covering the arts, media, gender-specific services, night patrol, mining, cattle management and a social club. Customary approaches to community-based dispute resolution were still being enacted, including sentencing and public forums. The Yuendamu Community Government Council was established. But policy upheaval in the late 1990s led to a policy of mainstreaming or normalisation. And Dr. Hinkson observed then a profound and systemic reduction in the authority of the Warlpiri elders, and the intervention in the early 2000s effectively disempowered Aboriginal people in remote communities. It introduced a vast new system of surveillance into their lives, which has had a devastating effect. The evidence before Your Honour also reveals the problematic interaction between the Cardia criminal law and Indigenous people. The huge number of Aboriginals and Warlpiri people who are incarcerated in the Northern Territory for offences across a broad spectrum reflects the disastrous relationship the Warlpiri people have with the criminal justice system. As has been observed during the course of this inquest, it was a justice system that the Warlpiri people had never wanted and that had been imposed upon them. For them, the application of that system is an ongoing catastrophe. The Brown family perceive that the prejudice and disadvantage they suffer every day in ordinary life is reflected in their experience of the criminal justice system. The Brown family see that Kumanjayi Walker was a byproduct of this history. His life as an infant was punctured with illness and attendance at hospital. When Ms. Oldfield gradually took over parental responsibility for him, she felt that she had a strong connection with him. As an infant, he suffered from serious health problems, including pneumonia, conjunctivitis and meningitis. The symptoms from these illnesses continued to plague him during his youth, in addition to the suspected FASD diagnosis. Kumanjayi travelled with Ms. Oldfield to Adelaide, where he spent time with his cousins, including Samara Fernandez Brown. She described him as having a calm presence and a quiet composure. He was quirky and fun. He enjoyed spending time with his family, and maybe these were the happiest years of his short life. She observed he was a much-loved member of the family. The evidence from police records reveals that as the years went past, though, he became increasingly disconnected from his family, found himself on the wrong side of the law, and he experienced significant periods of incarceration, and his imprisonment, he found, was distressing and confronting. The person who probably knew his overarching situation best was Kerry Chilvers. She said that when he was engaged in a program and participating in culturally based activities, his behaviour was rarely problematic. As a young man, when she managed him as a case coordinator, she observed he had a keen desire to learn and was generally well behaved. She recognised, however, that he suffered from symptoms of hyperarousal, consistent with indicators of an over-aroused sympathetic nervous system. The factors that she observed, she thought were indicators of post-traumatic stress disorder. And in short, Kumanjayi was ill and likely suffering from the consequences of significant mental health issues. In the criminal trial, Kumanjayi was described as a violent and dangerous offender. The Brown family was shocked to hear of him described that way. Their experience of him was quite different, and that experience was reflected in evidence from members of the Yuendamu community. Your Honour heard from multiple witnesses from the community who expressed their love for him. Alice Walker Nelson expressed that all of her family loved him, made jokes with him whenever he visited, and he shared with them what was going on in his life. Lottie Robertson described him as a happy and quiet young fellow. He had his moments, but he was, in her words, a really good young fella. Kumanjayi was part of the Brown family and part of the Yuendamu community. He was in Yuendamu in November 2019 to participate in sorry business and to attend the funeral of his grandfather. One of the tragic aspects of this event was that Kumanjayi was not only killed in the community, but he was killed in the home of his grandmother, Margaret Brown. As Your Honour has observed, Yuendamu is a small and close-knit community. From time to time, tensions flare and there are disputes between families. But for the most part, the majority of the community live in harmony. The extended Brown family live in several houses across the community, and those homes form an important component of their daily existence. In the community and in their homes, children are raised and families develop. Family who have left the community return home to sleep and eat there and visit their relatives. The community and their homes are the hub of Brown family life. So when the IRT drove into Yuendamu on 9 November 2019 and made their way around the community, first to House 577 and then to the Red House, brandishing their Glocks and long-arm rifles, they failed to accord any respect to the people who lived in those homes, the families and the children. The screams that could be heard on the body-worn video after the shooting were the expressions of fear, not aggression. These were the screams of women and children who had been witnesses to 3 shots fired after armed police officers brandishing rifles had entered their community. They were no doubt terrified who had been shot, who else was going to be shot. That they then observed one of their community members being dragged across the ground in front of them can only have been extremely confronting and distressing. The notion that an armed police officer with his hand on his gun might enter a house without permission just to check whether a person was inside after being told that that person wasn't inside would be abhorrent to most Australians. That a police officer would enter a family home and shoot and kill a family member is shocking. Very few people would be able to remain in a home where a family member was shot and killed. Margaret Brown, the trauma of the event occurring in her home has been overwhelming. The notion of the Red House being a home has changed forever. She has created a shrine to Kumanjayi, and the Red House is now a testament to his memory. And that memory is pervasively sad. She lives with that every day. After the shooting, family members congregated at the police station, not to fight with police officers, but to find out about Kumanjayi. People were calm, people were angry, but were restrained. The elders were encouraging the young people to be quiet. The court heard from Samara about the impact those events outside the station had, and there was an overall heightened anxiety about Kumanjayi's fate, but also fear about what the police might do in response to the crowd outside. She felt there was a need to record their actions, fearing the police would later say they were dangerous. And over time, as the vigil progressed, she felt disregarded and disrespected, as the police would not communicate with the family. The next morning, after Samara had gone to bed, watching the plane depart, hoping that Kumanjayi had been saved, she was awoken by wailing. The community then went into mourning. Everyone was fearful and emotionally distressed. And to find out that Kumanjayi had not been flown out, that the ambulance to the airport was all a charade, and that Kumanjayi had died at the police station, shattered her faith and the Brown family's faith in police and authority. We, of course, submit that the ruse was unnecessary. Communication with Derek Williams and the elders was the preferred course. In the days that followed, Samara asked an officer in riot gear about what was happening. He was blasé and defending the need for riot police, blaming the community for their presence. And whilst the family were undertaking sorry business on that very next day, she saw long-arm rifles being held near the Red House, and she felt this was a show of power, both insensitive and disrespectful. During the course of the inquest, there have been many witnesses who have expressed their sorrow and regret for the events that have occurred. The Brown family are hopeful that there will be an apology for the people of Yuendamu from the Commissioner following his recent statement at the Gama Festival. But the expressions of regret also reveal the depth and extent of the wrongdoing. For example, Sergeant Hand stated that it was very upsetting to him that the family of Kumanjayi did not know that he had died in the police station. He said he could understand how hurt and upset the family was, in particular Derek Williams, in knowing that he was related to Kumanjayi. Sergeant Julie Frost expressed her sorrow for the loss of Kumanjayi and a hope that the inquest could provide the family with some answers as to what happened. More importantly, she hoped that we could all learn lessons from this incident to ensure that this never happens again. She expressed the view that it was a tragedy that Kumanjayi died, and she felt very sorry for the loss to the family. Former Deputy Commissioner Murray Smallpage has apologised on behalf of the Northern Territory Police Force for the circumstances of passing of Kumanjayi, for the deception of the community in sending the ambulance to the airstrip, for the manner in which Kumanjayi's family members were told of his passing on the morning of 10 November 2019, for referring to Kumanjayi after his passing by using not only his first name, but an incorrect name, for the dragging of Kumanjayi to the police vehicle, and for the carrying of long arms in community after his death. He has also apologised for the racist and offensive text messages sent by various members of the force, for the TRG awards, for the Book of Truths, and the racist language and behaviour of various members. The Brown family acknowledge and receive these apologies, but they are acutely aware that an apology does not change their day-to-day existence. An apology, whilst received and acknowledged, has little weight if the conduct that was the subject of the apology continues unabated. Although members of the Brown family and the broader community were not in court each day, their presence on the court lawns demonstrates their commitment to the process. Supported by Yasmin Musharabash, Jay Davies and their team from the Australian National University, the Brown family followed the evidence of each witness very carefully. There were many people who attended the court lawns from the Walker, Lane and Robertson families, as well as the Brown families. From the Brown family, Jean and Margaret Brown were regular attendees with their niece Joyce Brown. Marguerite Brown and her family from Katherine attended. Kumanjayi Brown was regularly present. Stephen Marshall and his family travelled from Nunavut. Part of the task of the Brown family legal team was to inform the community on the court lawns about the events that had unfolded at the inquest on a particular day. And during the course of the lunch adjournment and after court, our team would gather the people on the court lawns and explain to them the evidence that had been given and the particular issues that the court was addressing at that time. These sessions were well attended, reflecting the importance that the Brown family and their supporters and the Walkley people placed on the evidence before the inquest. Despite their desire to know and hear the truth was not always easy to convey or for the family to digest. On many occasions, I recounted evidence that was very distressing to the Brown family and community members. For Leanne Oldfield, the evidence was so distressing, even in a watered-down form, that she was often unable to attend at the court lawns at all. I remember well the meeting on the court lawns at the end of May this year. I conveyed to the community the evidence relating to the awards that were handed out by the TRG, mocking Aboriginal people. I recall one family member who sat in front of me as I detailed the evidence. She looked across my shoulder toward the courthouse with a look of disgust and despair. This was the organisation that had descended on Nunavut following the shooting to quell the non-existent unrest that was supposedly about to grip the community. The discovery that they had for many years been mocking Aboriginal people with annual awards to their members confirmed the family's belief that Aboriginal people were perceived and treated by some members of the Northern Territory Police Force as a lower class of people, unworthy of respect. Irrespective of how difficult the truth was to confront, the Brown family and the Walkley people attended the court lawns each day as the inquest proceeded. And throughout the inquest and their quest for the truth over the past 5 years, there have been significant losses in the Walkley community that have devastated Nunavut. Some elders who attended the court lawns on a daily basis passed away without seeing the justice they hoped for and believed in. And I want to pay respect to elders Mr. Kumanjayi Nelson, Mr. Kumanjayi Brown, Mrs. Kumanjayi Marcel, and Mrs. Kumanjayi Egan. These people were pillars of the community and were frequently on the court lawns providing knowledge, strength, guidance and hope. They hoped for a better future for themselves and their families and waited patiently for the truth to be told. To the grief of their surviving family and community members, they passed before they could see that day. But despite all of this, the Brown family and the Walkley people are strong. As Ned Hargraves told the inquest, their people have suffered, and they know they have suffered. In his words, they know they have suffered because most of them have learned and seen what they have gone through. And today they still have the memories of the trauma of their history But they are Wamala, a nation of Warlpiri warriors. They are strong in their laws. They are strong in their culture. And even today, they are still continuing teaching their children. They have not lost their culture. This reflects what might be the most remarkable aspect of the Brown family and the broader Warlpiri people. Despite the forced and violent removal from their land, the devastation of their culture, the theft of their children, the incarceration of their youth, the infliction of poverty, and the massacre of their people, they continue to put their faith in this court and this institution that the truth will be told. Despite the lies that were told to them on the night of Kumanjayi's passing, the devastation and perceived unfairness of the criminal trial, the shocking evidence about the extent of racism within the Northern Territory Police Force, and the repeated legal manoeuvres of witnesses to avoid giving evidence and avoid telling the truth to this court, they are hopeful that the truth will be told. It is, with respect, an extraordinary statement of faith in our justice system that after more than a century of prejudice and devastation, they put their faith in this inquest in the hope the truth will be told. The Brown family have demonstrated resilience, patience, and respect at every step in the process. Immediately prior to the criminal trial, Samara publicly stated that the Brown family simply wanted justice to be done. Following the criminal trial and the devastation of the family at that outcome, she again stated, on behalf of the Brown family and their supporters, that they put their faith in the inquest, that the truth would be told. And each day they have sat patiently on the court lawns whilst their elders have quietly passed, awaiting that truth. The Brown family respectfully submit, Your Honour, that now is the time for the truth, and now is the time for change.
Thank you, Mr Mullins. Mr Bowe.
May I get an indication on when you would like to adjourn? Lunch?
I have no access to time here.
It's 12:20.
12:20. I'll just get some.
Your Honour, we normally stop at 12:30 for lunch. It's now 12:20, I'm told.
12:22.
Are you suggesting that we would take an early lunch?
Perhaps Mr Bowe could indicate his preference to whether we want to get 10 minutes done now or
Or we can sit till 1 if people can manage, but
I'm in Your Honour's hands.
I'm happy to sit till 1.
It may well be that I will be finished for sure by then, Your Honour.
Thank you.
May I just start by explaining that we've been asked to refer to the members of the communities in which the Walker Lane families live as Yapa, as we've done in our submissions, just so that those who are listening and may not be familiar with that term understand. And we adopt council assisting's references to the non-Indigenous community as Kardia. So that explains some of the language I've been asked to use. May I just start with acknowledging two events that have occurred in the last 48 hours, one of which involved Your Honour in terms of the publication of the domestic violence inquest. And we submit with great respect that it appears to us that there's probably no person in the Territory better equipped to appreciate the position of the Walker Lane families in the context in which they find themselves in this inquest. We make particular note of 3 matters that Your Honour is reported to have said, namely the reasons for high rates of violence in the Northern Territory were a variety of socio-economic, historical and cultural reasons. And secondly, and particularly important for us, these included the ongoing impacts of colonisation, including the impact of intergenerational trauma, systemic disadvantage and discrimination, cultural dislocation and removal of children, entrenched community attitudes towards violence, the expense of service delivery, and challenges of recruiting and retaining skilled labour, geographical distance and remoteness of some areas, and a lack of basic infrastructure. The third observation in adopting Dr. Dwyer's submission, it is a terrible waste of money to repeat investigations that result in similar recommendations, and it is a tragic waste of lives for them to be ignored or not seriously actioned. We make that acknowledgement because in this address, we don't propose to go into any detail in terms of the evidence that we have covered in extensive submissions, and Your Honour has seen those matters, and now it's not the forum, as far as we're concerned, to delve into that detail. We've made good our arguments, we've understood what's said against them, and hopefully that has assisted Your Honour to reach the right result. In line with not sugarcoating matters, it's important to acknowledge that the added factor in this inquest is that this death occurred in Yuendamu, a place which, as we have submitted, is a place where policing is a failed project. As noted by NT Health in their submissions, the Yuendamu community is overrepresented over all crime data. Property crime was particularly prolific, and while the Northern Territory has twice the rate of unlawful entries as the next highest jurisdiction in Australia, the rate of such crimes in Yuendamu is disproportionately higher again. It is important, and I know Your Honour well appreciate this, not to skip over or gloss over, or worse still, ignore such damning statistics in viewing the context of the proposals for reform in the engagement of police with this community. This inquest also concerns a death in custody in circumstances where the evidence has shown that a very significant proportion of arrestees in the Territory who are then held in custody are Yapa, and nearly all of them who conduct these arrests are Kardia, or non-Indigenous police officers, of whom the majority are male. Though there has been debate about whether race factors contributed to this death, it cannot be doubted that issues of race and mistrust between the Yapa community in Yuendamu and the Northern Territory Police Force lies at the heart of this inquest. The context in which findings and recommendations must be made is that this is not the first time that an Indigenous person has been killed by a member of the Northern Territory Police Force who has avoided any institutional or judicial consequence. In fact, none has ever been brought to account. Now, before we proceed with some specific amplification of some of the findings, we asked that a short video, which we note was recorded on the 20th of July 2022, be shown about the impact of this death upon the families and how they view this inquest. The video is of Lottie Robertson, who happens to be in court today, a senior member of the Robertson family and grandmother of Rakisha Robertson. It compels all of us to reflect what the families hope from this inquest. And may we have that video played now, Joram?
Yes.
It may well be that Maz will tell us, is there any update on playing the video?
So I have been able to increase the volume by 25%.
Okay.
You're right, because the volume at times is not expertly captured, I do have a number of copies of the transcript that might assist Your Honour in hearing. I'm happy
That would be appreciated.
I'll distribute some copies to others who may wish it, including the people in the media or other parties at the bar table.
And it may be that we'll be able to add that to the website to assist people to understand.
Thank you, Your Honour.
It probably can't be done contemporaneously,
Of
but
course.
we will.
And I am going to speak to some of those quotes for emphasis after the video is played.
Thank you. There are multiple copies here, so
They're 2 pages each. I'm sorry they're not stapled.
it's okay. I'll hand those back and they can be handed to those people who wish to be assisted.
Who was at the funeral, attending the funeral for Jean's younger brother. And we were all finishing up now. We're just returning to our car. Then we got a phone call. But everybody heard that shot. Yeah, they all raced down. We all raced back. And then I got a phone call from my daughter-in-law. Yeah, so-and-so has been shot. Yeah, and we all started after a big sad funeral with one of our family members. We had another thing going. And that was all, just too much, just too much. And today, we just can't get over that feeling, every time we got to think about it. We all cried in our cars, all driving back to that house. Everybody went into their house, what they saw there, it's really, sadness, came over them, what they saw, and then went out of the house, just crying. We all then decided we would all go to the police station, We all sat there for hours and hours, and crying. People were angry, and we were all still crying. My granddaughter and me and my family were all sitting in another group. There were family groups sitting there, but we all came together as one, and it was, hard for us to, get that feeling of how, yes, it's a really strange thing that happened in our community. It happens in other places, in America, in Africa, or wherever, in other states, in the state, in Australia, but not in Outback, like Yundamu. We had many police working here, getting to know the families, getting to know the culture. Many of our police force that are working here, they come to know the families. Anyway, but this is just a bad thing for the community that happened that day. It's just come like what he's talking about, praising him. What he's saying, it like where they can just come and shoot somebody, what they do in the movies, and it's hard to believe. How can we, keep on, we are strong cultural people here in Yundamu, Popanya, wherever, and we know that that kind of thing is not appropriate for us to be able to, us indigenous people, to see and know about it, or see what happened, because it's too much. Today we're still thinking about it. We're still talking about it. And how can we come up with that? Some police are good when we come to know them. That's why if they want to come to look for somebody, they gotta come to us, ask them. But some are good. They don't look for recognition. These community police that have been working here, I mean, they should be recognized for doing a good job. But they people like the ones that came in to do this thing took a young man's life. He's not a hero. He's just somebody who's took somebody's life. And it's for losing somebody like that, it's in our mind, it's in our heart, it's in our spirit. We still think about it. I don't know about him, the man who took his life. I don't know what he thinks. Yeah, it's just cutting short a young man's life. He could have just, they could have just found some way to be able to take him back without taking his life. Well, because, we need the government to understand, these people, they are joining the police force. They can't just come and, be tough in our communities. There are elders in these communities they can be able to talk to. We don't want another Rolf coming in our community to do these kind of things. We want to be able to work together. Whatever things, even government got to realize that we are the indigenous people of this land, and we want to be able to help our young people if they got funding. Yeah, but I'm missing him all the time. I talk about him. And if there is a way in the Northern Territory that those kind of things won't happen again in the territory. I know it's happening up in Darwin and all that, but here in the Central Australian remote communities, we want to be able to be strong. Build strong connection with the police that are working in the community, so that we can work together and not be able to, let others come in and do bad things in our community. We want to be able to be strong, just to look after our young people, because they are a generation. We won't live forever, but we want to be able to teach our young people and help them go through this life. Teaching them, talking to them, whatever things they are doing is bad for them, alcohol, whatever drugs they're taking. We want to be able to talk to them. There's a way that we can remember that young fella, to be able to help other young people save their lives. Yes. Because right now, every time I talk about him, it's just too emotional for me. Anyway. I know it's very hard for me to talk about this all the time. Anyway. Because I lived with him, I cared for him. I cared for him in this house. My granddaughter found joy and happiness with him. We talk about him all the time, and this is what we go through, even our family too. And it's a very a strange picture that we can see all the time in our mind. How his life was cut short by a stranger, by a strange weapon.
Your Honour, that was recorded 3 years nearly after Kumanjayi was killed, and about 3 months before this inquest started. Because the sound wasn't that clear, and perhaps some people listening may not be as biculturally competent as Mrs. Robertson, may I just emphasise 4 things that she said, which are terribly important to indicate the position of the families. These are Mrs. Robertson's words. This was a bad thing for the community that happened that day, like where they can just come and shoot somebody like they do in the movies. It's hard to believe. Some police are good. These community police who have been working here, they should be recognised for doing a good job. But the people like the ones who came in to do this thing took a young man's life. He's not a hero. He's just somebody who took somebody's life. You know, we need the government to understand that these people, they are joining the police force. They can't just come and be tough in our communities. There are elders in the community they can be able to talk to. We don't want another Rolf coming into our community to do these kinds of things. We want to be able to work together. That's a way we can remember that young fella, to be able to help other young people save their lives. It's very hard for me to talk about this all the time because I lived with him. I cared for him. I cared for him in this house. My grandfather found joy, my granddaughter, who's also in court today, found joy and happiness with him. We talk about him all the time, all our family do. And it's a very strange picture that we see all the time in our mind, how this life was cut short by a stranger, by a strange weapon. Now, Your Honour, has already been submitted by Counsel Assisting, has received thousands of pages in written submissions, and I think there's about 5,000 pages of transcript. So now is not the time for us to delve into that detail. If there's anything that we've submitted that Your Honour seeks for us to clarify, of course we'll do that, but we don't propose to rehearse their position in some particular matters. Before I get to the three specific points, may I just indicate a mild disagreement with some of the contentions or submissions that Counsel Assisting made this morning. We don't disagree with the notion that the Bush officers on 6 November 2019 should not be criticised for the way in which they conducted themselves. We are completely in accord with Counsel Assisting submissions on that respect. But in considering the matter, we do ask Your Honour to take particular account of the circumstances or the structural communication issues, as Dr. Dwyer conceded, as to the non-awareness within such a small community, within such a small police station, of the fact that there was a funeral, sorry business being undertaken in the community at the time of that arrest attempt, particularly in circumstances where Akpo Williams, who was on duty the day before with Sergeant Hand, was one of the people attending that community. It seems unacceptable that they did not know that one of their colleagues was having a funeral and the cultural importance of that, and to preserve or take steps that accommodated that in terms of arrest situations. The second aspect Your Honour, we ask Your Honour to take into account in assessing Counsel Assisting submissions on this issue is the non-utilisation of Akpo Williams on the 6th November attempt in circumstances where we all know that notwithstanding that he was related to Kumanjayi, he had arrested Kumanjayi several times in the past, peaceably and in circumstances where it sometimes took hours for there to be trust exchange between the arrestor and Kumanjayi for him to come in safely. Now, there are 5 matters which we will focus attention on in the next 15 minutes. As you've seen in our reply submissions, we've urged the finding that Kumanjayi was dehumanised by various institutional systems in the Northern Territory, including the criminal justice, juvenile detention, child protection systems, and the Northern Territory Police Force. It's important to remember, in understanding his vulnerability, that he was orphaned at 12 after his parents died at ages 31 and 40 respectively. Those statistics relating to him are a poignant reminder of his vulnerability from the start of his life. And whilst we must not sugarcoat his experiences, We would ask Your Honour not to put too much weight on any criticisms that may come of our clients, our families, and the way in which they sought to step in once he became orphaned or once he came into their care. It seems unique within First Nations across the country that people do take care for children who are not theirs at a much higher rate than the non-Indigenous community, that they have not been able to fully address all of his vulnerabilities or weaknesses should not be sheeted to their conduct or their behaviour. They have tried their best within a system that is woeful for all of them. Now, it's all too predictable that the failure of agencies responsible for his education, healthcare, meant that his young life was defined by interactions with an agency with no such mandate or capacity to address his disadvantage. The Northern Territory Police Force, with which he came into contact on the 9th of November, more than 5 years ago, when still a teenager, was not only one with a long and dark history of racism, which has been acknowledged, including, of course, the Coniston Massacre, but one within which racism was alive and well. He was killed by a Kardia man who referred to Yapa as Neanderthals and coons, yet told Your Honour with a straight face that he is not racist. It cannot seriously be contended that racism and systemic dehumanisation of Kumanjayi did not inform the events of 9 November 2019. Second, and Your Honour has seen a large part of our primary written submissions focusing on the finding that the entry into Kumanjayi Walker's grandmother's house, House 511, was unlawful. We are not going to delve into the detail of those submissions. Former Constable Rolfe has never asserted that he had the requisite belief that Kumanjayi was inside the house and claimed and maintained that he had been given permission to enter. While some, including the Northern Territory Police Force, seem to be, quote, uncertain, unquote, about this assertion, it is plainly and manifestly untrue. Worse still, the Northern Territory Police Force and some other parties remain quite nonplussed that this entry was unlawful, and the force eschews any institutional responsibility for what happened at that house, other than recognising along the way a catalogue of errors by various officers. Your Honour has all of the body-worn video which captures the entirety of what former Constable Rolfe and the IRT did once they got to Yuendamu. None of them had been there before, and their disrespect is palpable. Leaving aside all of the legal arguments, what is clear and apparent is that Rolfe and his entourage mimicked what they had learned in the ADF, brandishing military weapons to be a show of force, a instruction given by Sergeant Frost. They trooped into this community and to utilise or paraphrase Lottie Robertson's words, strangers carrying strange weapons. Former Constable Rolfe and his IRT colleagues were, quote, clearing houses, to use his language, with the arrogance and belligerent disregard of people embodying the confidence of unaccountability. This reckless conduct, and that of former Constable Rolfe in particular, created a completely unavoidable yet predictable circumstance of what has been called officer-induced jeopardy, not a term used by us, but by senior members of the force itself. While this description is accepted by the Northern Territory Police Force, alarmingly to us, they refuse to hold anyone meaningfully accountable for this catastrophic police operation. The third point is that former Constable Rolfe should not have been accepted into the Northern Territory Police Force. And having been accepted, he should have been dismissed well before 9 November 2019. The Queensland Police Service quickly determined that Rolfe was not an appropriate candidate, while the NTPF found him to be a, quote, prime candidate. Former Constable Rolfe then went on to demonstrate his willingness to use excessive force, disobey rules around the use of body-worn cameras, communicate in racist and homophobic language, and perjure himself. The Northern Territory Police Force failed to identify what was apparent to the Queensland Police Service, and then were willing to tolerate a standard of candidate and ongoing behaviour that was woefully inadequate, dangerous for the people they were charged to, quote, serve and protect, and ultimately fatal for Kumanjayi. This candidate then concealed his deteriorating mental health, his diagnosis and pharmacological treatment with a drug which, according to Professor McFarlane, quote, is associated with an increased risk of committing violent crime in younger adults, and which was, quote, likely to have impacted on his capacity for behavioural inhibition to threat. It was this NTPF officer who stormed through the community of Yuendamu as they were in the midst of sorry business, ignoring instructions from a senior officer, perhaps because she was a woman, as part of a leaderless, heavily armed and undisciplined team with the singular purpose of arresting Kumanjayi as soon as possible, completely unmindful of important cultural matters and by whatever means he thought necessary. The fourth point is that the families commend Your Honour for withstanding the specious and thinly veiled attempts by former Constable Rolfe to derail this inquest. Aside from the myriad of findings that must be made about him and the Northern Territory Police Force, it cannot go unobserved that even when finally compelled to enter the witness box, he showed little, if any, interest in assisting this inquest. His focus remained on a misconceived and patently untenable attempt to protect only himself and deflect and deny any responsibility for his role in what occurred. By the time he gave evidence, he'd got to the point, to use his words, of being bored with the whole situation. Transcript 58708. He has held steadfast to this narrative that he is the heroic police constable who saved a colleague. Despite his efforts and those of his supporters, he has been revealed to be a person who had no interest in gaining an understanding of the culture and people for whom he held a duty of care as a police officer. He freely used racist language in a range of contexts, including while on duty as a police officer, albeit only in communications with other police officers, evidencing a racist disposition. He was ever ready and enthusiastic about using use of force, including excessive force. He regularly failed to use body-worn video when he should have, and when he did, he at times used it to manipulate the depiction of important events. He thought it was okay to game the disciplinary process. He had a disregard for his superiors and bush cops. He was suffering from a mental illness, was taking medication, and declined to disclose both matters. And on the day of the shooting, he deliberately and arrogantly ignored Sergeant Ross' plan for a safe arrest, as explained by counsel assisting, supported by those who knew and had dealt with Kumanjayi before. The fifth point, and I will finish by one, Your Honour. Former Constable Rolfe is correct in submitting that this is and should not be a royal commission into him. However, the focus on him has been absolutely necessary to investigate what led to those 2.6 seconds when he shot Kumanjayi at close range on 9 November 2019, knowing that his actions would likely kill him. Having said that, too much focus on Constable Rolfe, former Constable Rolfe, creates a smokescreen for the Northern Territory Police Force, which has submitted that the events of 9 November 2019, quote, may be an example of the overly zealous, willfully impulsive or overly assertive policing style demonstrated by Constable Rolfe, unquote. That may be true, but the force cannot be acquitted of responsibility for the reasons we have referred to earlier and in our written submissions. It is of great disappointment to the families that the force, while acknowledging these mistakes, submits to Your Honour in their nearly 500 pages of submissions that there should not be any consequence for any one of the members of the force whose failings contributed to the avoidable and reckless policing disaster that unfolded and resulted in Kumanjayi's death. The NTPF, through their counsel, does this in two ways. Firstly, by arguments that there should be no argument, no examination, finding or recommendation in this forum about what happened in House 511. And as you all know, we've given you detailed submissions about why that argument is misconceived. And secondly, by presenting the engagement of Executive Officer Leanne Little, who I understand is in court, as impressive as she is, as being a complete panacea to any suggestion that adverse findings or recommendations about systemic reforms should be made. It is telling that after the families filed their original submissions nearly 3 weeks ago, where we pointed out the absence of evidence of what Ms. Little is doing, the context in which her independence is being guaranteed, and what resources are being provided to provide an independent analysis into the documented failings, no attempt has been made to put any evidence before this court other than statements in their submissions and submissions from the bar table. Your Honour should not refrain from making recommendations about reforms within the Northern Territory Police Force on account of broad and lofty assertions that are made about having already adequately adopted reform measures. Embracing Ms. Little's observation in her evidence that change would require more than hollow words, I quote, require more than hollow words, tokenistic window dressing, symbolic gestures and actions, unquote, in the absence of some concrete evidence about what reforms are being implemented. This inquest is left with more, this inquest is left with little more than just that. We urge Your Honour to recommend that the Northern Territory Government repeal the immunity provided in Section 148B of the Police Administration Act. The idea that in the Territory a police officer has a special immunity protecting them against criminal responsibility exemplifies the inherent racism in the system of policing in the Territory. Such privilege and the unaccountability that accompanies it can only act to embolden those predisposed to the use of excessive force and violence in the course of their duties which have them dealing with the most vulnerable and disempowered in the community with lethal weapons. As evident from Mrs. Robinson's evidence, but using our words, the stain of this killing is already steeped in the Yapa sense of injustice, compounding their memory of past injustices, such as the Coniston massacre, a stain that will only be cleansed by truth-telling about all the circumstances that led to Kumanjayi's death, no matter how painful some individuals and some leaders of government agencies may feel about being exposed for negative and racist attitudes about Yapa. We're very confident, Your Honour, and with great respect, that we don't need to give Your Honour a lecture as to issues of race, racism and racial discrimination. But there was a report released yesterday, which I bring Your Honour to Your Honour's attention. It was a report of the National Race Discrimination Commissioner, which was released yesterday and received some reportage in The Guardian Australia this morning. And I just want to finish with a few aspects of that to make good our point of how the notion of systemic racism remains an elusive issue for many at the bar table to grapple with. The news report included, quote, the National Race Discrimination Commissioner said it was the first time Australia had a comprehensive plan to tackle deeply embedded racism across the country. Through our consultation process, we heard consistently from First Nations and other negatively racialised people that systemic racism is deeply embedded throughout Australia and requires an urgent national response. In the time that I had this morning, I did go through the report, but there are 5 paragraphs which, unsurprisingly, correspond with some of your findings in the inquest from 2 days ago. We give that not for Your Honour's assistance as much, but also given the strident positions taken by the force and NT Health about their rejection of findings and how offended they are about the notion that such a finding might be made. These are the quotes from the Commissioner. We cannot effectively address racism and the harmful impacts it has without acknowledging its existence and then taking powerful action to confront it. Firstly, we must recognise that Aboriginal and Torres Strait Islander peoples, as the first peoples of this continent, have a distinct experience of racial injustice that arises out of their status as colonised peoples with unceded sovereignty and a denial of their self-determination. The next paragraph is probably the most important in the current context. At a basic level, racial literacy is about equipping people with the tools, confidence and capabilities to understand and challenge racism. If we only understand racism in its interpersonal forms, it's easy to say that we aren't part of the problem because we aren't saying or doing racist things to other people. However, when we understand structural racism, we know that we also have a responsibility as individuals to actively dismantle the implicit racism in the systems and the institutions we are a part of. Challenging the status quo is not an easy task. We have the strength to do it. The time to do it is now. The last matter I wanted to point to, and it may be slightly out of context, is that counsel assisting made the submission that there should not be any criticism about the way in which the members of the police force responded after Kumanjayi had passed away. In evidence, Leanne Little was asked about this specifically, I think by Mr. Mullins. The second example is that the evidence is that Derek Williams, a serving ACPO, was in the community on the day that Kumanjayi Walker passed. And then the question goes on to essay the fact that they weren't allowed in and the fact that ACPO Derek Williams was not told the truth. Ms. Little's answer is, that's another example of distinct racism or overt racism and systemic racism in the system. We join in that criticism. It's not about people acting out of fear and concern of personal harm. Of course, we can embrace that. I've never been in that sort of situation. I can't criticise the way in which people may wish to protect themselves in priority over other issues. But that is behaviour which falls into the structural racism to make the assessment, because they're Walpuree and some of us have dealt with them in the past and they're an angry mob. We're not going to do the decent thing on this occasion when it happens on our watch. It's in those circumstances that we submit that Your Honour is not alone in this vital conversation of understanding racism. However, your findings will be utterly important in assisting all of us in what must be done into the future. Thank you, Your Honour.
Thank you, Mr. Bowe. I think it's the lunch hour. We'll adjourn for, what time is it now?
It's now 1, Your Honour. If we can return at 2?
Yes, we'll return at 2.
Silence will stand. The Coroner's Court of the Northern Territory is now adjourned.
Do you have an evidence reference for that video that you just played?